Oops, went too far. Oh, that's me, Karen Ensley. And I am an attorney, and I have a specialization in construction law and I'm going to say subspecialization in roofing. So I'm so happy to be here to speak with you today. This is my second disclaimer. This is my disclaimer. So I have a lot of opinions about a lot of things. There are very few things upon which I do not have an opinion, and I have opinions on this law and how you should conduct yourselves to make sure that you are complying with the law, and some thoughts about some of the more esoteric questions that are going to come up as we see this thing fleshed out. It is a month old. It's a simple law, and it's fairly clearly written for laws, but we don't really ever know what a law is going to mean until it's tested. And in this case, we're talking tested by courts and tested by TDI. So what I'm telling you is not legal advice for you. It's my opinion based on what I see in the law, and even if you're my client, it's still not legal advice until you come and talk to me about your specific situation, because as is true with so much of life in the law especially, the facts really matter. And so that's all about that. Consult your own attorney to ensure that your practices comply with the new law. Very, very important. So I broke the law down into 3 or 4 slides. This is the beginning of the new law. It is a newly created chapter, Chapter 707 of the Insurance Code, and it says that a person insured under a property insurance policy shall pay any deductible applicable to a first-party claim made under the policy. So it is a have to, which really isn't any different than the previous law, but it's more specifically stated. So the insureds have an obligation to pay their deductible. This is new, and this is in the old section 2702 of the Business and Commerce Code, but this is newly written language. And so here is the good stuff, right, for all of us. So this, it has to be in your contract. Has to be in your contract, effective September 1st. It has to be minimum 12-point bold font. You can choose your font. But this has to be in the contract. If it's not in the contract, your contract does not comply with the law. Texas law requires a person insured under a property insurance policy to pay any deductible applicable to a claim made under the policy. It is a violation not to do so. It's a violation of Texas law for a seller of goods or services who reasonably expects, so we're going to talk about reasonable, to be paid wholly or partly from the proceeds of a property insurance claim to knowingly allow the insured to fail to pay. So that's the language that has to be in the contract. I recommend that's on the first page of the contract, and that you make sure that you point that out and have the property owner initial. And by the way, you have handouts in front of you, and all the slides should be in the handouts, but they're super tiny. So if anybody wants a copy of my slides, I'll be happy to provide it. Just email me. So then we jump back into the 707, and this is very new, and this is the part that you need to really understand. Is the insurance company now has the right to require reasonable proof of payment. So of course, reasonable proof, and it's set out here, and if the insurance company does not get reasonable proof of payment, they are not required to release the final check on the claim. So y'all can read, but it's a reasonable proof here, and there are some examples of what reasonable proof will look like, and these are probably the most common examples. Canceled check, I don't know who pays by money order, but I guess a money order. Credit card, payment receipt, and then a signed installment plan. So for those property owners who may not have the ability to write a check for whatever the deductible is, a signed installation plan is perfectly legitimate and perfectly complies with the law. But make sure that it's signed and make it a real thing, right? I mean, don't just make it a piece of paper that gets signed, because if you do, you're going to get in trouble. Just make it a real thing. A lot of, and so the question is all states already asking for it. A lot of insurance companies are already asking for that. It's nothing new. We see it a lot. It's just you're going to see a lot more of it. So just be prepared for that. So here's my initial analysis of the applicability of the law. It's for a contract for good or service, and that applies to anything that you all are going to be providing to your customers. Reasonably expected to be paid partly or wholly from insurance proceeds. So reasonably is going to be one of those things that's litigated, I promise you. If you have a reasonable belief that insurance is implicated, you're going to be required to make sure that this law is complied with. And then contracts over $1,000, which is everything. Now, it's only first-party claims for property damage, but that's what we all do. So here's the scary part, right? So I've actually excerpted out the portion of 2702 that talks about how a contractor can get themselves in trouble. So a person who sells goods or services commits an offense. And this is similarly written to 4102 in the Public Insurance Adjuster's Law. You can violate this law in two ways. One is by promising to waive, and one is by actually waiving. Right? So similar to 4102. The means and methods are the same, but they're broken out because you can not collect the deductible if the insurance company says it's okay not to collect the deductible. So anyone who advertises or promises to provide services under a property insurance policy in which the work is being paid for by insurance proceeds, and the person without the insured's, which is the insurance company's consent. And this is very, very broad. This is much broader than the previous law. Very broad. Cannot pay, waive, absorb, otherwise decline to charge or collect the amount of the insurance deductible. Very broad. You cannot provide a rebate or a credit in connection with the sale of the work that offsets all or any part of the deductible. Very, very broad. You cannot in any other manner assist the insured in not paying their deductible. So if paying, waiving, absorbing, otherwise declining to charge, rebating, or crediting wasn't broad enough, you cannot in any manner assist the insured in not paying their deductible. And then the same thing goes, that's the promise to do it, and then it's the identical language for actually doing it. And this is going to be tested, probably sooner rather than later. So it applies whether you're promising or actually waiving. It prohibits all of this stuff that you can't do. And the any other manner is very, very broad. So the analysis is going to be, did you collect the deductible? Yes or no? If you didn't collect the deductible, you're in trouble, because there's absent agreement from the insurance company. If you don't collect the deductible, you're going to have a very hard time avoiding violating this law. It requires reasonable knowledge, reasonable belief that the insured will pay for the work from insurance proceeds. So let's just dwell on that for just a second. If it's hail damage to somebody's home, I don't know, probably insurance is going to be involved somehow. So I'm going to have some suggestions here in just a couple of minutes, but just a cookie cutter, oh, they told me it wasn't insurance, is not really going to be helpful if this law starts being really strictly applied. And I think it's going to be kind of an abuse standard that's going to get applied. So yeah, we'll talk about that. It applies only if the insurance company is not consented. So interestingly, the penalty for violating this law, there's always been a penalty for waiving deductibles, and we don't need to talk about the old law because the old law is gone. But there was always a penalty, for waiving the deductible wrongly. The law has actually changed from a Class A misdemeanor to a Class B misdemeanor. So it's 180 days in jail and a $2,000 fine. I cannot imagine that any local DA's office has time to arrest somebody for not collecting a deductible. I don't see it. And, you know, I think Steve agrees with me. Unless you're really, you know, unless it really turns into a thing where you're doing, you know, hundreds of them, and it becomes so abusive that somebody with pull at the DA's office decides that it needs to be stopped. So I'm not really concerned necessarily about the criminal aspect of this, but just be aware that it's there, and depending on how the law matures and how it's applied going forward, you can actually, you know, have a criminal conviction against you, which is problematic. I think it's much more likely that TDI is going to issue fines and cease and desist orders. And I think we're going to see a lot of that in the near future until folks really understand that this is the law and that we need to comply with it. And I've had some questions since the law really looked like it was going to pass. I'm not going to dwell on those necessarily right now because we're going to have our Q&A. But one of the questions I got was, you know, whether one contractor could report you, and they can, but they have no power to see you prosecuted. So let me just talk real briefly about some scenarios that I probably are weighing on your mind. They certainly were questions that I had. So what contracts require the warning in them? They are contracts for construction, provision of services that are going to be paid by insurance proceeds. So a lot of folks have sort of a two-step process with their contracts, and they have a service contract, and they call it lots of different things, but in essence it is a contract that says, I will go out and evaluate your property, and I will identify damage, and I will provide that to you so that you can pursue a claim with your insurance company. And I will provide those services at no charge, and in exchange for me providing those services at no charge, you agree that if the insurance company does agree that there's damage and that it's covered, that I will be your contractor for the work. So when I'm talking about a service contract, I'm talking about that first segment of that process. So because a service contract is not being paid for by insurance proceeds, I do not believe that the warning language needs to be in there. If you want to just make sure that you don't get in trouble and you want to put it in there, it doesn't hurt anything. It's not a violation to have it in a contract you don't need it in. But just in case you have a question about that, I think that's the issue with that one. And then we have, as we all know, kind of two kinds of construction contracts, and the first is the contingency contract, and then the second is what's I think most commonly referred to as a retail contract, which is a stipulated sum. It says I will do this particular scope of work and I will do it for X amount of dollars. So the question is, does that contract need the warning language in it? Yes, it does, because it's a contract for services. So it's not just contingency contracts that require this language, it's any contract for construction being paid for by insurance on a property claim. So the reasonable belief standard, I'm just going to keep harping on that because I think that's going to be really important moving forward. I think the best practice is to have the homeowner affirmatively, the property owner affirmatively represent whether or not insurance proceeds are being used. And if so, what the amount of the deductible is, because we are not the deductible police. It is not our job to ferret out the information that the owner is obligated to provide. We have our job to do, the owners have their jobs to do. So if you go too far down that deductibles police road, then you end up potentially violating 4102, which we certainly don't want to do. So the owner can say yes, it's covered, or no, it's not covered. And if it's, I think you have the right to believe them and what their representations are. I recommend that the contracts that you're going to be using going forward have a little box up at the top that says insurance proceeds, yes or no. They can circle or check or whatever. And then the amount of deductible, have them fill it in and have them initial. Have them fill it in their own writing, not you, and then have them initial it. Because that puts the onus where it needs to be, and that's with the insured. Hardship cases, good guy discounts, etc. So how does this fit in? They still have to pay their deductible. I think as a contractor, you have the right to agree to do work for whatever price you want to agree to do the work for. Just understand that whatever that number is, that's the claim number. It basically, I think, turns it into a retail contract at that point. And the deductible is going to come off of whatever that number is. And we are certainly not going to inflate claims to cover deductibles and get ourselves in trouble. There is no sale that's worth that risk, just absolutely, absolutely not. If it really is a hardship case, then maybe the owner needs to go to their insurance carrier and ask them to waive the deductible, which the insurance company has the right to do, and which takes this completely out of our hands in having to collect the deductible. So I've been asked a lot how this law fits in with 4102, which is the Public Insurance Adjusters Act. And nothing in this law has any influence on anything in the Public Insurance Adjusters law. My opinion is they're completely separate, other than resist the temptation to become a policy cop, because it's too easy to slip from there into discussions on policy terms, etc. And that's a place none of us want to be there. I haven't seen anything in 2102, which is the deductibles law, that authorizes a court to void a contract. I've had several people ask me questions about that. For what it's worth, that's my opinion. Both are governed by TDI. So TDI used to be that the old deductibles law, the enforcement arm was the Attorney General's office, and they're so overworked that, forget it, right? Now, the deductibles law is under the insurance code, and therefore TDI is going to be the enforcement arm. So I think we're going to actually see some enforcement of this law, and I think we're going to see it really pretty quickly. Because I think that TDI is going to want to send a message that this is real, and we're going to insist that you follow it. So I think we're going to see fines, and we're going to see cease and desist letters. I'm going to skip this next slide because it's a Q&A, and we're going to save that for later. So let me just wrap up my portion of this presentation with some practice tips. The warning language on the front of your contract, loud and proud, I would put a little spot and have the owner initial next to it, or just have the owner initial next to it. Have your salespeople really make sure that the owner's aware of that requirement, because it is something that's going to be a sea change for a lot of people who have believed for years and years that contractors are just going to waive deductibles. So for sure, I would have that on the front page. I would have it offset, and I would have it at least 12-point font bold. Then we talked about a little box for the owner to say yes or no to the contract and to put in the deductible amount. Now, be aware that if the owner puts in a $500 deductible amount on the face of the contract, and for some reason you end up seeing the Xactimate from the insurance company, and the Xactimate shows that the deductible is $4,000, I'm not sure that you can get past the reasonable belief that the deductible was actually $4,000. So just understand that as important as knowing the letter of the law is, making sure that you're following the realities and the spirit of the law is going to keep you out of trouble. So if you have reason to believe that the deductible is really $4,000, collecting a $500 deductible, or whatever the case may be, is not going to insulate you from violation of this law. And then, as always, understand that you're responsible for everything that your salespeople do, whether they're your employees or whether they're 1099, just like having kids. You're responsible. If your employees don't follow this law, the business owner is responsible. And with that, I'm going to turn the microphone over to somebody who might be Dan Pitts. Come on up.